Hello, everyone, and welcome to Thursdays Live with Chug. Each week, we cover pressing topics that matter to you and your business. I'm Arianna Gonzalez from Chug Attorneys and CPAs, tuning in from our San Diego office. And joining me today is attorney Maureen Scorese from our Edison, New Jersey office and senior legal consultant Kaveri Vijay from our New York office. Hi there, Maureen and Kaveri, and welcome.
Hi.
Thank you so much for being here. For today's topic, we're going to be discussing the do's and don'ts of IP protection. We're going to cover the most pressing questions we get on this topic, so make sure you stay tuned till the end. Just a quick disclaimer for those tuning in, I'd like to remind you all that we are live on YouTube, LinkedIn, and Facebook. This conversation is for informational purposes only. It does not create an attorney-client relationship. So if you do have questions, please comment them below or email us at info@chug.com so we can help you out. So let's get started. Maureen, to begin, could you discuss why intellectual property protection is especially critical for startups in their early stages and how this lays the foundation for long-term success in their respective industry?
Sure, that's a really good question. So initially, the IP will protect the company's assets, and at the beginning, at its startup stage, the small business doesn't have usually a whole lot in the form of assets, and so it's primarily its business, and you need the IP protection to give value to that business. Oftentimes, a strong IP portfolio will attract investors to your company as well. If you don't have IP, it often scares those investors away. And so it helps you to start off successfully for those reasons. It also lays the foundation for future success and for future innovation, because in order to get your IP, you need to do your homework. Part of the process of obtaining intellectual property, whether it's a trademark, patent, or other IP, is to conduct research and do some due diligence to determine if your idea warrants the protections under the law. So that helps you understand your field and what is really new that you're contributing, and then it helps you protect it. So it should be part of the business plan for a lot of those reasons. It helps you understand also what's out there and to not copy or infringe the other IP of other competitors in the market space.
That's great information. Thanks, Maureen. It is important to remember to put that in the business plan. So, Kaveri, if a company, for example, is contemplating commencing business operations in the United States, would it be advisable to get their trademark or trade name registered, considering it might be a lengthy process? What are your thoughts on that?
Yeah, thank you, Arianna. Yes, I think it always helps to get the registration process ongoing because, as you said, it's a lengthy process. And even though the company is contemplating business operations and putting together their plans and resources here, in the meantime, that name reservation for their trade name or trademark can give them that ownership of their branding in the company when they start commencement of business. That's very helpful for business operations. And the security of having that trade name and logo or symbol already in your own ownership, so you don't have to redo all your marketing, you don't have to redo all your paperwork, your letterheads, everything that you need to go by your company's branding is already set in place. So definitely, yes.
Thank you for covering that. That's really important for people in this situation and going through this process to keep in mind. So Maureen, could you give us some insight on how domain name registration plays a part in a startup's IP protection strategy?
Okay, so the domain name registration should be part of every business, in part because we all go to the internet these days to get information, including information about other businesses. So you will want to make sure that you protect your name and how you want to have that online presence for your business. And the process about choosing the name, deciding what domain name registrar to use, and who's going to host the website is all part of the process. It is the domain name is separate from the trademark. Sometimes people will confuse the two. And sometimes a domain name can become a trademark depending on how it's used, but getting the domain name is a very important part of the process.
That's really important for our listeners to know. It's really an essential part of the process. So make sure you are taking that into consideration. And if you do have questions, check with your IP attorneys. We're always happy to help you guys out. So Kaveri, what are some key terms that one should consider in an IP licensing agreement? I know you have quite a bit of experience on this topic. So what would you typically suggest to someone on this?
Yeah. So IP licensing agreements are very common nowadays, considering so many software licenses, subscriptions are taken in to account. Some of the key terms would be, first of all, defining the exact accurate purpose and scope of the license, because a lot of times we've seen conflict come in here. Parties generally write a vague or a very broad scope, not realizing at the time of execution that becomes a big problem, because what the two sides are expecting is by far very distant from each other, and that culminates into a dispute and payment not being made, saying service was not good enough, it was not as per the agreement. So one, your purpose of the license has to be very clear, for what all software and for what all functions is it being given, and the time period for a license, because it cannot be given in perpetuity, so it cannot be unlimited time, so it has to have a time cap on it, right? Of course, then you have your general liability provisions, your indemnities, but something where operationally, commercially, we have seen issues crop up and disputes come up are mostly because of scope, license time period not being correctly defined, and of course, the purpose for which we are giving. So the scope would cover the purpose as well, but the scope will elucidate the actions and the activities that are going to be covering, that are being covered through that license.
Those are all really great things to consider. Thank you for going into detail about that, Kaveri. Those are all truly essential for this process, for someone who is filing a trademark or looking for IP protection. So what considerations should startups have, for example, if they're dealing with a joint development or collaboration in terms of IP protection? Is there anything we need to keep in mind for this?
Okay. Yeah, Maureen, go ahead.
Okay. So as far as a collaboration situation, you need to identify clearly what each side or each party in the collaboration is bringing to the table. Oftentimes, the entities are bringing their own IP or their own ideas, and that needs to be clearly defined at the outset, so everyone knows who owns what and who's contributing what. If the parties are contributing IP, there needs to be included also a license to use that IP for research and development or whatever the collaboration end goal is. And so you want to understand that that license should continue into perpetuity or not. If it ends with the end of the collaboration, what happens to that background IP, they call it. And then for the development of IP, right? If you're doing a collaboration, you're developing something, you're working towards some end goal, and there's a possibility of new ideas being created, new inventions. And so you need to clearly identify who will be the owner of the new IP. Is it like copyright or patents or whatever is being created? Are you going to keep it a trade secret? Who will own it? And so then you need to have the NDAs to protect it, assign ownership and all of those terms as well. So collaborations are really great, and it helps to be successful to address these things early on so that everyone understands where the project is going and eliminate the possibility of any disputes.
Those are great insights, Maureen. It's so important to make sure everyone working on the project is on the same page and, everyone is in agreement with the next steps and what the overall picture is. So I appreciate you diving into detail about that. Kaveri, are there any, and if so, which IP protections that can be negotiated by a startup while they're raising funding?
Yeah, so often we do see that's the biggest, not issue, but the kind of concern that because startups are what they are getting funding on is their product, which is technology in most of the cases, and the company, the investors would want to keep that technology with them. And at the same time, the startups have put in all, it's their idea, it is their, hard work in developing that idea. So they ideally would not want to let go of that technology, and ownership would be with them. So there is a very thin line between the two, because the company would let them exit if, say, it is not making profits, or it's not scaling up the technology, and would just want to keep the IP with themselves still. But generally, in most of the cases we've seen, like in a JV situation, which may not happen with an investor directly in a startup scenario, but say in a JV, the company owns it. It's ideal for the company to own it rather than the investor and the investee. And in a startup situation, then the company could go through valuations and see what is the value of the technology, and then do an exit price if they are leaving, the investor is leaving with that, or what could be the exit price. Or if the investee is going to leave, and want to have the ownership, then the price adjustments can be made through that. So it is really depending on the commercial. But yes, ideally, the sentiment generally remains is that the startups would like to keep the technology, because they have developed it. It's a more sentimental and emotional value, actually, if you really ask. But at the same time, it is on the commercial. So it's always good to seek legal advice here. What your structure is, what you're bringing to the table as a startup, and then what rights can you have to protect your IP in front of your investor. So legal advice here will really help you to take it forward. Yeah.
Those are some great points you brought up, Kaveri. And of course, yes, definitely seek help with your legal professionals. If you have questions, make sure you are doing this process correctly and you're not missing anything, because we definitely want to make sure we have a good foundation set up and everything is laid out properly from the beginning, so that, we don't go back and find errors later down the line. So I appreciate you sharing those insights, Kaveri. Maureen, can you share with us how non-disclosure agreements may vary across regions? And are there any clauses that startups should pay attention to in this process?
Absolutely. And so as the world is always becoming smaller for businesses, these are really important aspects to consider. The enforceability of a non-disclosure agreement will certainly vary across regions. So if you're in the US, it's certainly enforceable in the US, right? But if you start to work with people outside of the US, or your business partners in the US are working with others outside the US, you have to consider, how far is my NDA protected and enforceable? So you really want to pay attention to that, the enforceability of the contract. You want to be aware of certain countries with weaker IP protections, and also to be aware of those countries where there's a higher prevalence of theft of ideas and innovations, and where knockoffs and things can occur. And then also know the local government regulations relating to your business. So again, this will impact where you want to do business, where you want to find collaborators, and invest in growing your business. The other aspect too, as far as what changes and varies across different regions, is privacy protections. And that goes hand in hand with how well you can enforce your NDA. So you also would want to know local protections provided by the governments where you're operating. Some of the key clauses to think about when you're contemplating these types of collaborations and agreements is primarily to have a clear definition of terms, parties, requirements, and most importantly, what is your confidential information? What are you trying to protect with the non-disclosure agreement? It's always important to have a definition section to set out the terms. You also want to make sure that you identify for how long it's in effect, and if other parties, often, I mentioned before, you might be working with people who your business partners have other contacts in other countries. And in that way, you can require your business partner to maintain the confidentiality through their business relationships. So it's your NDA is only as good as it covers your business and what others are doing with that information. So it's always good to step back and look outside the box to make sure you address all of those concerns.
That's really helpful information, Maureen. I appreciate you touching on all of those points. I know you talked a little bit about privacy, so I do want to dive into that a little bit more. Kaveri, can you tell us a little bit about how trade secrets and sensitive information can be protected, especially when this information is often being disclosed to employees and third-party service providers? What can businesses do to protect this information?
Yeah, Ariana, thank you for that. It's an important point because every day we do see a lot of issues crop up because of this, because companies are sharing a lot of their business information, client information, uh, material that they have researched and studies about market competition. So a lot goes into the hands of employees and third-party service providers. So ideally, like Maureen was saying, a good NDA certainly helps to protect that. You know but at the time we do see there are breach of those clauses, and employees irrespective go forward, or it may not be intentional, like an employee has gone back home, is speaking to his family, and somebody from the family has disclosed it to somebody. It's unintentional, but a big mishap has happened because of that. So there have to be strict prohibition of disclosure of really confidential information apart from authorized representatives, or if it is required under the exemptions only that for that purpose it could be permissible. And in case there is a breach, then of course we have legal remedies. At times also because it is considered a theft, because often employees leave, and we have sometimes even seen, Maureen have worked on some cases where they took the laptops, they took the tabs and everything in which all the company data was in. So that could also amount to like theft of data, and we could go the legal way in filing some kind of legal action against that, or also go to the police for filing a complaint, for theft. So it could be either of those cases. We have to see. We don't want to be too harsh. Of course, these are very extreme steps. But yes, I think awareness programs really matter a lot. Time to time, companies should, have awareness programs for employees to make them understand what confidentiality is, what sensitivity of that data is. Because sometimes when we sign our employment contracts right at the time of joining, after that, we never see them again and we forget about all that. So I think this concept has to be instilled in employees again and again as part of training, and then it stays in your head, and the seriousness of this aspect.
I love that point you brought up, Kaveri, and then that's really important to consider. Oftentimes when employees are starting a company, that isn't something they're really focused on. They're just signing things, and to refresh the memory and remind them, what's in the agreement and why it's so essential that this stays confidential. And that's a great reminder and great insight for companies to consider. To make sure that their precious trade secrets stay secrets and stay within the company, and don't get outside where they don't belong. So thank you for sharing that, Maureen.
I'm sorry to interrupt. I had
ahead.
a couple of comments to add to that as
Please.
well. One thing that comes up often is just making sure things are identified as confidential. It takes a little bit, one extra step, right? But it's one way to like clearly put it on the documents. If it's electronic or if it's in paper form, just have a stamp, right? That says confidential either on the outside or, on every page in case it gets mixed up or separated. And then another thing too that I've come across with different situations is when you're doing a collaboration or even just generally in-house with your employees, to have a reporting process in place. So as projects are being worked on, you don't realize how much IP can possibly be created. It could be lost, pushed aside. And so just having a routine reporting mechanism as well to sort of make people stop and think, hey, did I create something that's copyrightable or could go towards a tech transfer into a patent? Something along those lines. It's just good to have some procedure to capture that IP.
Those are wonderful points, Maureen. Thank you for bringing that up and interjecting and letting us know, there is more companies can do to ensure that the important information does stay confidential. So I appreciate you guys really covering that for us and giving us all of your insights on this, because I know you guys do have quite a bit of experience in this. So We always appreciate your insight. Maureen, let's say, for example, a startup does suspect that their IP has been infringed upon. And let's say they're dealing in a foreign market. So what are the first steps a startup should do? What action should they take when they're in this situation, when they feel like their IP has been infringed upon? What advice do you have?
So the first thing would be to stop and ask yourself, do you have IP protections in that country, right? A lot of people might get IP protections in one country and then expand and be so excited and focused on the expansion, they forget to also obtain IP, patent, trademark protections in the next country where they're expanding. And so that's the first thing before you do anything. Stop, back up, and make sure that you have registrations or at least applications to protect your IP. If you do, then you can send the cease and desist letters. But you'd be a little foolhardy to send the cease and desist letter first, and then your competitor receives it and goes and files for their own registration to beat you, right? So I would do it first, make sure you have the proper protections in place, and then you can send a cease and desist letter to a competitor or somebody who's infringing on your IP. And then there's options after that. You can try to work with the other party. Instead of being a competitor, you could try to make them a business partner, depending on the circumstances and the personalities involved. You can also file a lawsuit to get an injunction to stop the competitor from hurting your business. There's a lot that goes into all of those decisions, but those are some of your options in that situation.
That's good to know that we have quite a few options in this situation. So definitely, if you feel like you're in this situation, contact your legal professional, figure out what the best next step forward is. You definitely don't want to take this lightly. So please reach out if you guys do have any questions on this. Kaveri, can you touch on how online and offline content can be protected?
Yes, very relevant for today's time, especially in the e-commerce world when everything is online. And of course, offline has been the tradition. So, a lot of companies and clients have come to us with this question. And what we often say is like, it's always getting a copyright registration for the content helps. So far, recently, going through some online websites, I did see even the page and photographs that were put and the content, there was a copyright registration certificate put right next to it saying that all photographs and all content on this page belongs to the owner, of this page. So I think people, because what they do is they take pictures from one site and then paste it on another. So in a nutshell, of course, we can go very deep into this, but it always helps to have that copyright protection for content. And of course, your agreements have to be in place if you're signing it with any service providers, third parties, any partners, business partner, clarifying who has the ownership of that content and material. That should be clear. It should not be taken in, and it should be very clear that if the other party has to use that content and material that is given on the website of the owner, it has to be licensed and approved first, without which it would be a breach. So your contracts have to be very well drafted, covering these points. And of course, for your own protections, you must go for the IP protections that are available right now to protect your material, your content, literature, photographs, even design layout, for example. Yeah.
Fantastic. Thank you, Kaveri, for covering all of that in a short span of time. I appreciate you sharing, how these businesses can protect their content online and offline. So Maureen, can you talk about why it's important for startups to consider IP during mergers and acquisitions? Is this something they should consider? If so, why?
Absolutely. So it should be looking at IP during an M&A transaction is just the same as looking at the books and seeing whether they're profitable. It's also part of the risk to assess as well. There's not just profit, but there's also risk to look at when you're looking at IP of a company. And so it gives you some value. It's another way to value the company, right? So it definitely is something to consider. And the analysis of their products and services with respect to what's covering their IP versus what's not covered, right? So if they don't have any IP protection, then that would be a liability. They could potentially be infringing another company's IP and just not realize it. And it could just be a time bomb waiting for a lawsuit. So it is a very important part of the M&A process, and it doesn't get as much highlight, in my opinion, when there is an M&A. And so there's so many other aspects everyone's looking at, but IP is definitely its own subset of due diligence that is necessary.
I appreciate you emphasizing the importance of that. And, I'm glad we're talking about it on this video today. So hopefully our audience can, take this into account and see the significance of this. Kaveri, question for you about online aggregators. Can an online aggregator be responsible for services provided by third-party service providers?
Yeah, thank you, Arianna. Again, a very relevant point, because in the e-commerce world, this is what we are seeing most of the time. One distinction has to be made. Sorry about the noise in the background, some emergency, I think. Online aggregators are one, when you're signing a contract or when you yourself are an online aggregator, the main service that you're limited to is about hosting the website. Beyond that, any third-party service providers who come on that website, whether they're giving services, selling products, or for the content they're putting, ideally it should be the third-party service providers' responsibility for any of the services or products that they're providing. An online aggregator's responsibility will only ideally should be limited to hosting the website, functioning of the website. So there has to be, though people assume, like, any online aggregator, we go by their branding that we got this from so-and-so, website like XYZ, But at the end, if you see the contracts in terms of use, they disclaim all liability because that's on the third party provider, right? So terms of use have to be very clearly defined to disclaim any liability, clearly demarcating what is their responsibility, what are their obligations and liability, and for what, like for any services that they're taking from any other party provider or service provider, it would be basically limited only to that service provider's provision of that service, and not be coming on the owner of the online aggregator. So basically, these are terms of use which have to be carefully drafted, making sure disclaiming liabilities have to be correctly put in place. Yeah.
Thank you for covering that, Kaveri. That's really helpful. Maureen, we were talking a little bit about infringing upon existing rights. So how can startups ensure that their IP doesn't inadvertently infringe upon existing rights? What steps can businesses take to make sure that, they're not stepping on anybody's toes?
Absolutely. It's a good question. So if the company has its IP, right, it's already gone through the research and the confirmation that there is protectable intellectual property. If it's continuing to develop its business and products and services, it should continue to file patents applications or file the copyright registrations in order to continue to protect what it's developing. It's not just a one-time thing, you're one and done, like, oh, we're gonna start off in year one, file for all these applications, and then by year 10, I'm sure your business has changed. You've adapted to the environment, the market, all the fast changing aspects of each of the areas of business. And so in that regard, you continue to file applications, and it's if someone were to send a cease and desist letter to you and accuse your business of infringing its intellectual property, that application that you have, even if it's not granted, is your defense to say, no, we're developing our own stuff, and this is how we have identified it in these patent applications, and we're protecting it. So it's a great line of defense to have something like that in your back pocket. The other thing is freedom to operate opinion. So if you do get a letter from a company that's alleging you're infringing their intellectual property, then you can hire an attorney and say, hey, check this out. Are we really infringing? And that's where you get the attorney to assess the intellectual property and then your own business operations. And you can have, if they are able to provide you with an opinion determining that your business is not infringing these patents, then that would be another defense as well. So there are legal options for you to build your own portfolio, but also have these research memos in your back pocket to defend against any potential infringement litigation.
Those are really great things to keep in mind. Thank you for sharing that, Maureen. It's something that, you know, every startup needs to consider. They definitely want to make sure that they're not infringing upon any existing rights when they're going through this process, so that they, like we talked about earlier, have the good foundation set up properly from the beginning. So Kaveri, you were talking a little bit earlier about online aggregators. Are there any liabilities for the online aggregator? What do these individuals have to keep in mind in terms of liabilities?
So again, it really depends how they have protected themselves in contracts and in terms of their websites, disclaimers in terms of use. Liability obviously should be capped. And if you're an online aggregator, it should ideally be limited only to the services of hosting the website and, regarding the functioning of the website. Apart from that, everything content that your third-party service providers are bringing should be their responsibility, and ideally it should never be brought on the aggregator themselves, right? So these are the liabilities. Of course, somebody can sue them, but then you can have back-to-back indemnities asking the third-party service providers to indemnify you for any such claims that are brought upon you. So a good draft, a good legally vetted draft, can protect most of these liabilities, and it can give you a very sound platform from exposing you to like an uncapped amount of damages and any extra liabilities that you don't want to take apart from what services that the aggregator is providing. Yeah.
That's important to consider for anyone, in that situation. So Maureen, we were talking about startups and IP due diligence. How should startups approach IP due diligence when they're partnering with other firms or vendors? What do they need to keep in mind?
So this question is very broad. So, I could go off anywhere on this, but it's just at the outset, it's another cost of doing business. So I see our clients and people who I talk with about this, always looking at it as an expendable cost. Like, well, maybe we'll put our efforts into developing the product, but the IP is so costly and we don't see the value, right? It's not as tangible as seeing a new product that you can put on a shelf. But it is a cost of doing business, and it improves the success of your business and the strength of your business in the market. So it's really important. So that would be my main theme here for that. I feel like
on that a little bit. I have like a follow-up question for you on that one. Like how do changes in international IP treaties and agreements impact startups aiming for a global presence? Is this something that we should also keep in mind?
So it is, and this could go on as well in a whole separate discussion, obviously. So I'll touch upon this in just one aspect. At a high level, there's definitely regional and international treaties, agreements that impact businesses. You can see it even on imports and tariffs and companies deciding where to distribute their products based on some of those import-export controls and extra costs involved in how to do that. The other thing, it'll impact where you operate, where you manufacture, where you get the materials to manufacture, right? So there's a lot that goes into this, and at which level of your business you are working internationally. The other thing that's really interesting in the last 10 to 15 years is how much sustainability is becoming a high priority in international businesses. One of the things we've all heard about is corporate responsibility and trying to be more socially aware, socially involved for community well-being and everything else. And I just wanted to highlight, I was reading a report that the World Intellectual Property Office Association had put out. WIPO, we refer to it, as far as development and the impact of intellectual property and how it relates to the sustainable development goals that have been published since like 2015. They're becoming much more mainstream in the media and more talked about these days. And there's definitely a correlation where there's a lot of IP that is being developed on some of the sustainable development goals, especially with the environment, technology, and just overall economic growth. So you definitely need to stay vigilant and adapt your business to stay competitive to the world market. But I just think that there's so much that you can look into here if you are an international business to take advantage of. Maybe there's government incentives to help with some of these. There's a lot of social media that's pushing these sustainable development goals to be part of everyone's business.
Thank you for covering that, Maureen. I know this is quite a big topic, so maybe we'll save diving into that for part 2. If anybody wants to see that in the audience, please leave us a comment below so we know what you want to see for part 2. We are almost running out of time, so we do have time for one more question, and then I will have to close this out. So, Kaveri, what role does IP play in the valuation and scaling of startups, especially during rounds of investment? Do you have any insight for us on this?
Yeah, thank you, Arianna. Again, a very good point, because that's something when we're doing valuation of a company, IP is again an important asset. And especially if you're a technology company, then, it will be based purely on your technology, your software that you have developed. But the thing with IP is like, there is no certain value, because today's technology can be redundant tomorrow. So, we have to always see in the present time what value that technology is bringing to the table, and also foresee a projection going forward in the next 5 year or another few years business plan. How much potential does that technology have to scale up? That will it just go out of the market just like that, or will it be able to sustain competition, keep developing, and keep the customers and the market involved with that technology? So there are various factors, of course, anything to do, but it cannot be completely negated, because right now everything is very e-commerce based, online based, very tech based. So all that has to be considered. A very valuation point, it's very important, but then there has to be a foreseeability of the technology also, that in tomorrow's world, how much it can generate revenue, profit, and how much it can cover the market space that an investor may be looking at to invest into that technology, based on that technology at least. So it's a close call. One has to look into the business scenario, look into all the business plan projections, and then come to a definitive figure in terms of valuation.
Thank you for covering that, Kaveri, and thank you so much, Maureen and Kaveri, for your insights. That is all we have time for today, so that does bring us to the end of our conversation. Thank you so much, everyone, for joining us today. To stay up to date, please subscribe and follow us on Facebook, LinkedIn, and YouTube. And if this video was helpful, please make sure to give it a like and turn on the notification bell so you can be notified of our next upload. And if you have any questions or suggestions, please feel free to email us anytime at info@trube.com. And make sure to join us back here next week for more pressing topics that truly matter to you and your business. Until next time, stay safe and take care. Thank you, everyone.